Here. Did this lady mix these two different cartons? So one is each of these things. Oh, yes.
Ma'am, are you Carol Robinette?
Yes.
Okay. You know if Mr. Robinette was going to join in this hearing today?
I believe so. Would you like me to text him?
Yeah, I do have somebody connected on an iPhone, but they're not turning on their microphone or their camera, so I don't know if that's him or not.
Can you hear me?
Oh, yeah, I can. Yeah. Is this Mr. Robinette?
Yes, it is.
Okay. All right, we'll go on the record now in Robinette versus Robinette. This is case number 2411728. The record should reflect that both parties are connected by Zoom video for this hearing today. I have this set as a date to enter a consent judgment of divorce. And Ms. Robinette, did you want to go forward and finalize the divorce today?
Yes.
And Mr. Robinette, is that how you'd like to proceed as well?
Yes.
Okay, if I could have you both raise your right hands. Mr. Robinette, I can't see you, so if you could tell me once your hand is raised.
It is raised.
You both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you. You can both lower your hands. I'm going to be asking you each a series of questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Robinette, as the filing party, my questions will start with you. You filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And do you agree that you and Mr. Robinette have already divided up any personal property between the two of you?
Yes.
And that you've divided up all your debts, or each of you will be responsible for the debts that are in your family?
Yes.
All right, and then there's an addendum to the judgment of divorce that reflects it looks like two different parcels of real estate. Is that correct?
Yes.
So the parcel on North Higgins Lake Drive in Roscommon, that is going to be awarded to Mr. Robinette. He's going to be responsible for any debt associated with that property, and you're going to sign over your interest to him. Is that correct?
Yes.
And then the property on Cypress in Taylor, Michigan, that's going to be awarded to you. You'll be responsible for any debt on that property, and Mr. Robinette will sign over any interest he has in that property to you. Is that correct?
Yes.
Aside from those things, Ms. Robinette, are there any other matters regarding the division of any assets or debts that remain for the court to decide?
No.
Are you asking to have your last name changed?
Yes.
That's to Evans, is that correct?
Yes.
Thank you. Mr. Robinette, were you able to hear all the questions that I asked Ms. Robinette?
Yes.
Were you able to hear all of her answers?
Yes.
Do you have any reason to believe that any of the answers she gave were untrue?
No.
And in terms of the division of any assets or debts, do you agree with the division of those assets and debts that I outlined here with her on the record?
Yes.
And from your standpoint, do there remain any issues regarding the division of any assets or debts for the court to decide?
No.
Under the judgment of divorce, Mr. Robinette, you also would not be receiving any alimony or spousal support. You understand that you also would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. Court will sign the judgment of divorce, which will be final as of today's date. Ms. Robinette, that means that from today forward, your last name will be legally changed back to Evans. So you'll need to change your identification and other documents. The judgment of divorce will be available. If either of you would like a copy of that for your records, you can get that here at the clerk's office in Grayling. Ms. Robinette, do you have any questions at all?
I do not.
Mr. Robinette, do you have any questions?
No.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Good afternoon, Your Honor.
All right, good afternoon. Mr. Rizzo, you're here on behalf of defendant Munson.
Yes, Your Honor.
I don't see Ms. Filiatro joined in yet, so I'm going to give her just a minute. If you just want to stay on hold here for just a minute.
We had an opportunity to speak over the phone about an hour ago, so I'm confident that she's aware of this and will attend.
Yeah, looks like she's signing in right now.
Good afternoon.
All right, good afternoon. We're on the record now in Walker versus Munson Healthcare. This is case number 2311516. If I could have both counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Rebecca Filiatro appearing on behalf of the plaintiff, Tiffany Walker.
Good afternoon, Your Honor. Nick Rizzo here on behalf of defendant Munson Healthcare Grayling.
All right, thank you. Looks like the last time we talked was back in August. I know I got a report from the mediation that indicating that the parties did mediate this case in the middle of August, but were unable to reach a settlement. So this is set as a status conference here today. Ms. Filiatro, on behalf of plaintiff, can you just kind of give me an update and how you see things going forward here?
Well, Your Honor, thank you. I spoke to Mr. Rizzo earlier this afternoon, and we talked about getting a trial date versus, trying to get the case resolved. When we had two facilitations with William Carey. The last facilitation, plaintiff was at $95,000 and defendant was at $7,500. So there's still, we're pretty far apart, and he wasn't able to get us any closer. It's a pretty straightforward case. It could probably be tried in 2 days, I would imagine. For plaintiff, we're still willing to talk settlement. But I think the defense would have to come up with some more money than that.
All right, thank you. Mr. Rizzo?
Your Honor, I agree with everything that was just stated. I think if we had a trial date, it might encourage the parties to engage in more meaningful settlement discussions, although that's not to be said that meaningful settlement discussions haven't already started. We've been facilitated mediation now on 2 occasions.
Okay. All right. I'm assuming that based on Ms. Filiatro, your statements regarding the mediation, that this is a jury trial?
Correct, Your Honor.
Okay. Ms. Filiatro, how much time would you like to have to be ready for trial? How far out do you want the court to get this set?
I was just talking to Mr. Rizzo about this too, Your Honor, this afternoon. My schedule is looking pretty tight for the remainder of 2024. My situation's a little bit further complicated by a very long premises liability death case that I'd be trying in Oakland County Circuit Court, starting February 11th. Those are that's kind of where I'm a little bit hung up on the date, but.
Okay, Mr. Rizzo?
Your Honor, just looking at the calendar, it looks like the last 2 weeks of February I've got tentative trials scheduled for those 2 weeks. But then starting in March, it looks like our calendar is free wide open.
Okay. All right, then I will set this for a 2-day jury trial in March. Typically what I do is about 30 days prior to the trial date, I set what I call a trial preparation conference. That would be a time where we can discuss final witness and exhibit list exchange, any stipulations that the parties are gonna have, you know, the composition of the jury, how many jurors we're gonna want to constitute a verdict and so forth, just kind of the nuts and bolts of how the trial will go. And then that date is also a cutoff date for any motions in limine that the parties are aware of or anticipating. You can file those at any time, but that would be the final date for the court to hear any motions in limine that would need to be decided prior to the trial. And the court will send out a notice of the date and time for that trial prep conference. But it'll be about 30 days prior to the trial date. And then again, I will also send out the notice of the date and time of the 2-day jury trial. And we can go through there. Ms. Filiatro, are there any other dates that you would want the court to set between now and the trial date?
I don't think so. None for plaintiff, Your Honor. Thank you.
Okay, Mr. Rizzo?
None that I can think of at the moment, Your Honor.
Okay, so I will issue a scheduling order just based on what we've discussed here today. And then again, my office will send out to you both the notice of the date and time of the trial and the prep conference. And that's all I have. Feel free to disconnect. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
recording.
Sounds like something particular.
Yeah, they have some issues since the new change.
Part of it is that all that equipment being right next to the body.
That's a petty. All right, if I could have the attorneys unmute, please.
Morning, Your Honor. Afternoon.
Whether-
Morning somewhere, but not here.
All right, we'll go on the record now. This is now McMahon versus Halstead, case number 1910666. If I could have both counsel put your appearances on starting plaintiff.
Good afternoon, Your Honor. Eric Phelps appearing on behalf of plaintiff Haley McMahon.
Good afternoon, Your Honor. John Moodhart on behalf of defendant Ryan Halstead.
Okay, we're on the record here today. There was a referee's recommended opinion and order issued regarding which school a minor child will attend. That was objected to, and so I did receive both briefs of the parties. And so Mr. Phelps, Mr. Phelps, you're asking for a hearing on those objections, is that correct?
That's correct, Your Honor.
Okay. Just to explain to the parties, and counsel may already be familiar with my procedure, but anyway, I view it as a de novo hearing that the court will take new evidence on. However, I'm going to make the decision based on the entire record. In other words, based on the testimony and evidence that was presented to the referee and any new testimony and evidence that's presented at the de novo hearing. One of the limits that I place on the de novo hearing is that the court will not hear evidence and testimony that was already presented in front of the referee, because I'm going to consider that. So what I would be considering at the de novo hearing is any new evidence that's come to light since the referee hearing. So any new or additional testimony, and then any testimony from witnesses who were not heard by the referee because of time constraints or the unavailability of a witness. So with those kind of limitations in mind, Mr. Phelps, how much time do you think you would need to set aside for the hearing before this court?
Well, I think there's a couple issues, Your Honor. In the ordinary course, part of what Your Honor is referring to would rely on the transcript. I don't know if Your Honor's had a chance to look at the transcript here. The court reporter in communication with Mr. Moodhart and I in June indicated that the recording, her words, like I warned you, this is absolutely horrible. You'll see some lines, and sometimes I put where I guessed, sometimes I put blanket statements in. I'm embarrassed to put my name on this. So the transcript is a problem. I don't know how that impacts the court's process, but I simply want to point that out. I think Mr. Moodhart and I would both agree that it's gappy, for lack of a better term. There's just pieces of the hearing that didn't pick up on the recording that the court reporter wasn't able to transcribe. So I don't know if that impacts the court's thought process. In a normal situation where there was a full, complete transcript, I'd say half day, but we don't have that type of record here, Your Honor. It's a bit of a problem.
All right, thank you. Mr. Moodhart?
Yes, Your Honor. I agree that the transcript is problematic and it's not a good transcript. Having said that, when I was drafting my closing argument to the referee, and also in connection with my response to Mr. Phelps's objection, I found only maybe one or two occasions in which the quality of the transcript had any impact. Really only one that comes to mind at this moment. And so there is a transcript. It's not a complete transcript. There are pieces of it that are missing, but there are a lot of pieces of it that are not missing. And I think that it's possible to simply, connect the dots to some extent. I would agree that if there's something that's missing in the transcript that somebody disagrees with, for instance, my characterization of Ms. McMahon's testimony on an issue that the transcript is incomplete on, that would be an appropriate place to have potentially, clarifying testimony. I don't think that it could be argued otherwise, but other than that, I don't think it can't be a complete do-over, because the transcript and the parties' briefs to you are reveal a lack of much of a dispute about most of the issues that I think you need to be concerned with. So that's what I'll say about it. I mean, and I don't want to have a problem down the road because we assumed that something was done at the referee hearing that we don't agree on and can't prove happened. That is not what I want. But again, I don't think you can just throw the whole thing out. There is a transcript.
All right, would you agree, Mr. Moonhart, that half a day would be enough time if the transcript were not an issue?
A half a day would be enough time from as far as I know, but of course it's not my objection, and so I'm not certain what is contemplated. I'm not the one to ask, I guess, respectfully, Your Honor, on that. We will respond to whatever is presented, and we would need enough time to do that. Mr. Phelps would know better than I what that looks like.
All right, Mr. Phelps, do you need any particular period of time to be prepared to go forward? In other words, how far out do you want me to set the hearing?
The only thing I would say with regard to that, Your Honor, is I'm in court essentially every day through the 8th of November. So some point after that would be useful. Otherwise, I'm going to have a bunch of hearing conflicts with scheduled events at this point.
Okay, so if I were to set this somewhere 30 to 60 days out, that would be enough time.
That seems fine, Your Honor. That's correct.
Mr. Moonhart?
Yeah, Your Honor, all I would say is that I've got lots of hearings and lots of courts and lots of dates between now and the end of the year. And so I would appreciate the opportunity to participate in the date selection so that we don't end up having to, it'll be quicker, easier, and more efficient if we can have some sort of a collaborative process to select that date.
Certainly open to that, Your Honor. I think it makes sense.
All right, so what I'm going to do is I'm going to set aside a day for the hearing on this. I'd rather set aside a little extra time and not need it than have to try to reschedule more time after that. And plus, I'm sure the parties want to get this matter decided. So I'll set it one day aside. I'm going to ask counsel for the two of you to confer together, come up with, 3, 4, 5 different dates that would work for the two of you, and then contact my office. And I'm going to ask that you do that within the next 14 days. And then just notify Jennifer at my office of the dates that you have and see if you can get one of those to work.
We can do that, Your Honor.
All right, Mr. Phelps, anything else I can address for your side today?
No, Your Honor. Thank you for your time.
Mr. Moonhart?
Thank you, Your Honor. We appreciate your time as well.
Okay, thank you. That's all for today, and all parties are free to disconnect on this file. All right, on the phone at 4840, last four digits, is that you, Mr. Gray?
Yes, sir. Yes, Your Honor.
Okay, thank you. Just one moment. All right, Mr. Vernon, are you able to hear me okay?
Yes, Your Honor. Can you hear us okay?
I can. All right, so let's go on the record. This is Sherry Marker Gray versus Robert Gray, case number 2311522. The record should reflect all parties are connected by Zoom video. Mr. Vernon, this is another hearing on this issue related to the sale of the marital home and the federal lien that apparently is on that home. Can you tell me where things are at from your side at this time?
Yes. We've had, I and my office have had several conversations with the Olivia Brooke from the Attorney General's office. And it is clear to me that the proceeds from the sale of the home have to be divided between Sherry and Robert, essentially without any attachments or any other considerations. So that it simply it has to be, he gets half, she gets half, or she gets what she paid in and then his half. And his half would go to the settlement of the lien that's on his federal criminal restitution lien. So I've been having conversations with Mr. Gray regarding the way to create that language and draft that's sufficient to address all of the parties' concerns. We have not reached an agreement on that matter. So we're still asking the court to set aside the consent judgment because that consent judgment is based on the parties selling the home and then using those proceeds to pay off debts, and then using those proceeds that they would each be entitled to pay the other for certain pieces of property. Mr. Gray wouldn't have any of that money because it would all be assumed under the lien and go to the federal government. So he's not in a position to pay those expenses that are under the mediation agreement. And we can't satisfy the first sentence of the mediation agreement of the settlement part says that the first be applied to mortgage obligations, then the proceeds of sale will be secondly applied to the Visa credit card balance. Well, that part can't be done. I mean, you can't apply it to the Visa credit card balance because the Attorney General is going to object to any portion of the money that is awarded to Mr. Gray goes to them. I mean, that's their money. So we can't use the proceeds of the sale of the home to do that. Money has to be divided first, and then that money goes to the government. And then the assets and the division of property can occur after that, essentially. So what we have proposed, we drafted several different proposed consent judgments that identify essentially Mrs. Gray getting what she paid into the home, originally the $78,000 that she paid into the home, or $72,000 that she paid into the home, plus some additional money for things that have already been sold by Mr. Gray. That's her portion. And then because Mr. Gray doesn't have any cash with which to pay for the things that the mediation agreement was suggested, would be that he would let her have side by side, which has debt on it, but has probably some equity, and she could sell that, pay off the debt on it, and then recoup some of her expenses through that. Mr. Gray reviewed that. We sent it to him on the 8th. He sent back several emails to me in my office suggesting that he would not accept that. So our position is the same. The mediation agreement and the consent judgment cannot be satisfied as they're written. And the consent judgment needs to be set aside essentially for either fraud or mutual mistake. I mean, either way, the parties can't satisfy this. And Mrs. Gray had was not aware of the lien when she entered into this agreement. Now, if Mr. Gray also did not know, then it's a mutual mistake, and that's grounds for setting it aside. If he did know, then it's fraud. So one way or the other, there's grounds to set this aside. The reality is the contract can't be performed due to that information. And so we basically have to come to a new agreement, but that has to start with setting aside the original one. And that's what we're asking the court to do.
All right, thank you. Mr. Gray, what's your side of this?
Well, none of that is really true. So if we back up to the original, the first, I think it was the second from last court date in your jurisdiction when we found out about the lien. There was a deal in place.
Let me I just want to stop you for a second. You said none of what he said was true. So tell me what parts of what he said is not true.
Okay, the part about him sending me agreement, I sent them 4 proposals in the last 2 weeks. They never replied to any of them. And they sent me a vague proposal on the 8th with the same amount that I had sent to them in my proposal. Mine explained where the money would go. Theirs was vague. So I turned around and I sent them a message yesterday. What happens with the side-by-side? Because the side-by-side has a lien on it, and no one would give me an answer. So I can't sign nothing. I tried to negotiate with them. I know he's a busy man. I get it. But I've been trying to negotiate with them to get this resolved. I went as far as giving her, here's the original problem, Your Honor. They'll never say it, but I was awarded $23,000 in this case towards the money that was put down on the house, the $72,350. Your court honored or gave me $23,000. From that day, they never will say that I had $23,000. So she thinks that when we had the agreement set aside, that was $85,350 with all the attachments to it. Him and her are taking I don't know how you would say it, but the stance that was her money. Only $62,350, that money was hers. $23,000 was mine, and I gave it back to her so she could pay half of the credit card and pay off the side-by-side. That's what that deal was. And in that but obviously it changed when they made the agreement and the government seen it and said, no, you can't do that. And I said, no, they can't do that because she told us we couldn't do that. The money, I could set money aside for Sherry, we had to have receipts, and then the rest of the money was split. Well, when they added the credit card and the side-by-side in the property, the real property part, or whatever that paragraph is, I knew it was gonna work. It wasn't gonna work, and it hasn't to this day. And to this day, we've talked, negotiated, and they will never admit where my $23,000 is. So with that being said, this is what I came up with, Your Honor. I would let her have all the $72,000 she put down in the house. I produced receipts that the government accepted for $1,500 on the four-wheeler, $1,500 on the storage container, and $12,000 for the Kubota, which she would get half. So that came out to $79,800. I said, she keeps $62,350, which she was allotted. She can pay half of my credit card or our credit card for $5,500. Then she could apply the rest of it to the side-by-side, and that within 30 days of closing on the house, I would pay the side-by-side off. Everything's done. They didn't like that. Well, they never said nothing. They never said nothing. So then I came up with another one. I'll give you $79,800, $62,350 is yours, $55 for the credit card, and then take the $12,500 and split it amongst my 2 kids. She got mad about that, but that's not in writing, but that's fine. We argued about it. And then I came up with another one. Just give her the $79,800 and she gets her $62,250, and then she can do whatever she wants with the money. If she don't want to give it to my kids or our kids, that's fine. If she doesn't want to pay the credit card, that's fine. All I asked for was, what are we going to do with the side-by-side? I put $10,000 of my own money on that side-by-side. So me and her never discussed, or Mr. Vernon, about taking that side-by-side and selling it so she could pay bills. That was never discussed. No one ever asked me, and I would not agree to it. What I was going to ask was, since I changed my stance, gave her all the money, let me let me buy the side-by-side for what's owed on it. That's all I asked. So that's what I'm saying. None of that stuff true. We never talked about the side-by-side selling it. But if you even ask them today, they still won't admit that $23,000 is my money. They won't mention it. But where is my $23,000? Whether I get it or not, or the government gets it. Oh, that's another thing here too, Honor, I got to be honest. One of my agreements was, I said, she gets her $62,350 out of the $85,000 or no, $79,000, or the government can have the rest. Because I'm not giving it to her. It was never hers. It's my money. Either she pays half the credit card, gives it to my kids, or pays for the side-by-side, or it goes to the government. That was my stance, because the way she treated me and all this, which is my business, I wasn't giving it to her, because it's not her money. It's my money. I was awarded it. That's where I'm at, Your Honor.
Okay. All right. Thank you. Mr. Vernon, it's your motion. Anything in response?
So the $23,000 he's talking about is the mediation agreement states, fourthly, payment would be made to Robert in the amount of $23,000, period. Finally, any remaining balance will be split between the parties. So where he says that's his money, I'm not sure. I'm not sure where that comes from. That's simply part of the agreement that as a disposition of the proceeds from the sale of the home, he would be awarded that portion.
No.
So the problem with that is that the agreement says that they would sell the Kubota, the storage container, and split the proceeds equally. Well, he sold the storage unit, the storage container and the Kubota to a friend of his at a very reduced price without an agreed upon price from my client, and my client hasn't seen any of that money. He has not paid her the $2,500 that he was supposed to pursuant to the agreement. He has not paid her the $1,250 that he was supposed to pay her to the agreement pursuant to the four-wheeler. And he has not, right. And then the Kubota was the thing, again, they didn't get a fair market value on the Kubota. He simply sold it to a buddy of his to his uncle for $12,000 on a piece of equipment that would have likely sold for twice that.
Yeah, right.
The $23,000 is subsumed into those.
No.
I guess I would say those unethical will be the word I will use. Sales and actions by Mr. Gray. So I think that the proposal that we have, again, I'm not suggesting that you're going to be in a position to negotiate or reach an agreement for us. What I'm suggesting is that all of the things that were agreed upon in the mediation agreement cannot be satisfied. The storage unit's already been, or the storage unit's been sold, the Kubota's been sold, no fair market value was ever assessed to them. The Visa credit card bill can't be paid the way it's intended out of the mediation agreement. So, I mean, if the court doesn't set aside the mediation agreement or set aside the consent judgment, then we have to turn around and immediately file some sort of breach of contract or show cause on this because he can't satisfy those terms. I just think it makes more sense to set this aside. Let's work with the Attorney General and the Realtor to get the numbers where they need to be and then go forward.
I have a lot to say, Your Honor.
Well, I'm not going to, Mr. Vernon's right. Like, I'm not here to negotiate for you guys at this point.
But can I say one thing?
Let me finish saying
okay.
Let me finish saying what I'm going to say, and then I'll give you a chance. My only decision today is we have a consent judgment that was entered into by both of you. You both agreed to that was missing an essential item, which is that there's a federal lien on your home that affects how and whether or not that judgment that everybody signed can go forward. And that's a really important and substantial factor here. And so, you know, unless what you're going to tell me is going to relate to why that lien wasn't brought up as part of negotiations or what effect that lien has, I'm not sure. You know, it sounds like you just want to complain about the negotiation.
No, I don't want to negotiate, Your Honor. I've tried to negotiate. What I'm going to tell you is that we had a court hearing from your court, and it's in the divorce agreement about this federal lien. Everybody knew it. The only thing that screwed up that federal lien was what he did when he put the credit card and the side-by-side in the real property when he knew it wasn't supposed to go in there. That's why I got the court transcripts from the court. And I knew it was, he's wrong. And another thing is, my $23,000 never came out of the house money. It was out of the $85,000 because I was awarded $23,000 out of the $72,000 that she put down on the house. Go back in the court records. It was $72,300 she put down on the house. You awarded me $23,000, Your Honor, of that money. That's where the $23,000 come from.
You guys, I didn't award anybody anything. You guys are the ones that
Okay. Okay. We have a signed divorce decree. So that goes back to another thing. Hold on, please. One more thing, Your Honor. They keep on saying, I sold this stuff. I sold this stuff. We've been divorced since April 4th. Look at the receipts on when I sold everything after the divorce, Your Honor. We're divorced. I've sold it, but I gave her fair market for over fair market. I had to sell it because I didn't have a job. But I never told her she wasn't getting the money. She's still getting the same. She's getting the exact same amount of money right now from the day we filed the divorce was final to she's getting now. She was never getting more than $62,350. That's the whole point. She was never getting more than that. She was only getting on the $72,300 she put down the house minus my $23,000. Then you add in the stuff I gave her for the side-by-side, I mean, for the four-wheeler, for the storage container, for her lawyer, half of my truck. That's where the money came from. She was never getting any more than $62,000. She's getting that now. I got the court transcripts from our court dates. She was never getting what she's getting the exact same amount. The only difference is she wasted 9 months of paying house payments on a house to go after the exact same thing she was already awarded. Now they want to open this all up and let's go waste all this time. It doesn't make no sense. I'm giving her everything she wants. She's getting the money again. She's getting her money for $62,350. She's getting money for a credit card, and I just gave her $12,500. That was my money. I don't understand why can't we just end this right now? And one more thing, Your Honor, you can call Olivia yourself. She will not negotiate with anybody. That's not their job. So this is just a waste of time. I'm giving her money and more, but it's your court, Your Honor. You do whatever you want to do. I understand.
All right. In my view, we've got a problem with this consent judgment that was entered into by the parties that's going to prevent either side from performing their obligations under that agreement. And I don't think it's an issue of fraud. I don't think it's an issue of mutual mistake. I'm looking at this as pure impossibility. It's just not going to be able to be accomplished in the way that both sides contemplated it and in the way that it's set forth in black and white in the consent judgment of divorce. So the last thing I want to do is open up a case that I thought was closed to. Takes up time on my docket. It causes delays for both of you, and I get that. This is not it's not an ideal situation for anybody involved. So I don't do this lightly, but I just don't see that there's any way that either side can perform their obligations under the consent judgment of divorce as it was entered into because of this lien issue. So for those reasons, the court is going to grant the motion, the court's going to set aside the consent judgment. The court is going to order that the parties go back to mediation. The court's going to order that occur within the next 60 days. And the court will set this for a status conference at the close of that period of time. Mr. Vernon, you're free to continue to engage in discussions with Mr. Gray. It sounds like he has submitted some proposals to you guys. So to the extent that you haven't responded to that, I think this is only going to work if both sides are communicating back and forth. And we'll see where we're at. If the parties are able to reach an agreement, then we can go forward at that time. If they're not, then the court will set this for an evidentiary hearing. The court will take evidence and testimony about all the remaining issues, and the court will make decisions to get this resolved. So, Mr. Vernon, if you can prepare an order that reflects that ruling in the court today and submit that on the 7th day rule.
Do you want me to submit that? Do you want the, just that the mediation or that the consent judgment set aside, or do you want me to include the mediation to occur within 60 days in that order as well?
Yes, please.
Okay.
Thank you. That's all I have for today. All parties are free to disconnect at this time.
Thanks, Judge.
Thank you.
That also concludes the court's afternoon docket. Court will be in